spinning around.
Hey.
There we are, going live. Thank you, everybody out there who are here. Appreciate it. Not legal advice and J.R. Ewing. It's funny when people call you J.R. Ewing. Because who calls you J.R. Ewing a lot?
It's Ewing.
Yeah.
You almost pronounce. I mean, look, go watch. If anybody's confused on the pronunciation, go watch Dallas.
Okay, there we go. We haven't, obviously we've been a while, like more than a week, so we figured we'd bring you up to speed today. And by the way, this is obviously not legal advice. This is just, even though I say this, I actually mean it. This is just our opinion. Don't rely upon anything we say. Do your own. Obviously I focus on this much more now today than I used to, as I was sued for making comments on my social media. That action has now been dismissed, so it's no longer pending. So, but you have to ponder what you say, because somebody, if they want to be difficult, can make your life difficult. So if you're talking publicly, just be careful about what you say and how you say it. And just because we say it's opinion doesn't make it opinion. It just gives it a name. It's really, if you give false facts, that's really the issue. So anyway, we're going to talk about a little bit about GTII. We're also going to talk about Doge, not the coin, although we could talk about the coin too. Do you own any Doge, JR? Have you ever?
I own no crypto.
Have you ever owned Doge?
No.
Never. Okay. I did. I probably wish I did today, but I don't. But we're going to talk about the non-agency. And
I remember, just a quick story about crypto. I remember reading back in 2010 about Bitcoin and thinking to myself, this is a piece of garbage. Who would buy this shit?
Yeah. Good choice. Instead, you saved up all your money and you bought MMTLP.
Yeah.
That's what you did. That's right.
Yep.
Yeah. Which will be interesting, by the way. It'll be interesting to see what happens. Matt Getz, we're going to talk about this, but Matt Getz, I think his name is pronounced Getz.
Yeah, it's Getz.
He was nominated for Attorney General. Whether he's actually makes it through, that's a question.
It's not looking good already.
No.
They're already coming out. Coming out about him. They're talking about releasing the ethics report.
Yeah.
So
I saw Republican senators who were
a couple of them
skeptical, and they can only lose 3 votes. Somebody else described it. It might be like sometimes they throw out when they're throwing out nominees, they know that some of them are going to get rejected. So sometimes they might throw them a bone so that they target them at somebody and they can get somebody else through.
Well, that's kind of, honestly, that's my thinking with Getz. I hate to say it, but I think he's going to be a no-go right from the start. And Trump's going to leverage that with someone who he really wants. I'm surprised he resigned from Congress already. Good Lord.
Yeah, well, he did, because what I'd heard is they were going to release the ethics report. So once he
they're still going to do that.
No, they will not. Once he
already talking about it. It was just on the news. 2 senators, a Republican and Democrat, were both like, "Look, this report needs to be released."
Well, but the way maybe they could do that, but the way it's handled generally in the House, at least that's what I read. As soon as the person resigns, the investigation's terminated.
Well, the investigation might be terminated, but you know what I mean. I mean, it's politics. It's Washington.
No, it is.
What happens.
Obviously, if he has to fight the release of the ethics report, his chances of getting confirmed are probably not very good. That's the bottom line. Yeah. What was interesting today, I think a guy was named the new New York, the Southern District attorney.
Really?
Jay Clayton, from who used to, I guess, was the SEC head when Trump was in his first term, at least for part of his term. But he was an attorney at Sullivan and Cromwell, which my son worked at, so I'm familiar with that firm. And I guess he's hired as Southern District. But they haven't chosen yet, and this is all relevant to us, they haven't yet chosen the SEC head. Gensler basically today, at least what I heard today, he basically, without saying it, he said goodbye today.
Yeah, pretty much.
Yeah, he said, you know, great crew. You guys have been great. You've been a great studio audience out there. Thank you very much. And sounds like he's out. And the name that I heard is the guy, the attorney who's the head of legal at Robinhood.
Yeah, you know, that was going around on Twitter here a few weeks ago. And then just a couple of days ago, I saw something about Hester Pierce because I posted about it and said, you know, you earned my vote. You put her in office, and I'm going to be pissed.
Yeah,
that's going to be the telltale sign whether or not he plans on cleaning up Wall Street. You know, you're going to know right from the start, whoever he nominates, if it's an outsider, he's serious about cleaning up Wall Street. If it's an insider, we got 4 more years.
There's a dual mandate here because he's also set himself up as the crypto guy, right? So whoever he puts in charge of the SEC can't be anti-crypto. And Hester Pierce, for example, she would be anti-crypto. No doubt in my mind.
Yeah, you know, I think those two choices were just rumors. You know, he hasn't come out and said anything about it. I'm watching. This is the one I care about. You know, all these other people getting nominated, whatever.
Yeah, I'm predicting it's tomorrow after hours. He's gonna name, just like he's done it every day. Like this week, it's been after hours or after close of market.
Well, I'm sitting anxiously by my phone because I'm waiting for the phone call.
All right, it's possible. It's possible. So, but it'd be interesting to see who chooses. I would bet if he chooses somebody who's pro crypto, that there will be a reaction in the crypto market.
Oh my God, it's already
hysterical because people think, because I guess there's going to be a bill introduced in Congress when they go back into session, apparently, that will support the U.S. buying 5%. Yeah, 5% of all crypto, Bitcoin, as a reserve currency. And they would buy it, I think, over, like, I don't know what increments over a period of time, but they'd want to get like 5% of the total and have that as a store of value as a reserve. So there's going to be a bill, apparently. Senator said they're going to introduce a bill to that effect as soon as the Congress gets back, which I think is January 6th, I believe. That seems like a familiar date, doesn't it?
Yeah.
I think that date, they go back into session. Since the Republicans have a majority in the Senate and the House, and since the president says he's pro-crypto, I would guess the bill is probably going to get passed and then probably get signed. And I would think if that happened and and I don't know, by the way, if this is going to happen, but that's what I hear is going on in the background. If that happens, I would assume there'd be a big bump in Bitcoin. My guess, but I don't know.
Well, it's already up $20,000 in the last 2 weeks.
I used, by the way, I used crypto as my bet on the election. I bought MicroStrategies, and I bought iBit, and then obviously it's not financial advice, but I figured, if the election went, because I had a particular feeling the way the election was going to go. And I had it a couple months ago. I felt fairly confident. I wasn't as confident necessarily as it went on, but at that time I was. This was post Biden stepping down, but I had a feeling about the way it was going to go. And the cryptos have been great. The Bitcoin, not everything else. Sure. I think Dogecoin went up because of Doge, and the Solana went up because whatever. I have no reason. I have no understanding of why it went up, but it's been very active, as you indicated, and there was a halving, and we'll see. It's interesting. It's interesting. I have no idea really what's going on, but I chose that as a hedge, and it's been working so far.
Yeah, I don't know. There's a couple of theories out there about why it goes up. Somehow it's connected to the halving cycle every 4 years, and every 4 years it spikes like this.
Yes. It has a cycle.
I don't know enough about it to understand why it's doing it.
Yeah, so theoretically it has a 1 year kind of cycle, a positive cycle, and because there's less Bitcoin being produced, literally each halving, so the theoretically it becomes more valuable, and at some point in time you're producing no Bitcoin. And so if somebody buys 1,000 and you're producing 400, that's kind of a natural shortage, which, law of supply and demand kind of kicks in there. So but I guess it exhausts, and again, I'm no expert, like at a lot of things. Apparently it exhausts itself at some point in time. People take profit, and then it kind of goes back, and then it does its thing until the next halving event. So we'll see. I guess the only thing that's different about this time is apparently there are, or at least there's rumors that there's countries that are purchasing, besides what I mentioned about the United States possibly doing
I believe it.
Yeah, so there's countries doing it, and if there's countries doing it, then that obviously it's supply and demand. If there's a limited supply, unlike almost everything else, there's a certain supply, you can't increase it. So if there's more demand, the price goes up. But we'll have to see. We'll have to see how it plays out. I'm obviously very interested in that. So we're going to talk a little about GTII. The second interim report just came out. It is 53 pages long. It is really long and kind of boring, to be honest, but it's really detailed. We're not going to go through all 53 pages, but what I kind of do is I was going to go through the highlights and ask JR to comment where he thought there was something interesting to comment upon. I can also bring you kind of up to speed about where things are and kind of where I see things going. First of all, so I don't control anything. So I don't control the lawyers who are in charge of our case. I don't control the receiver or the receiver's counsel. And there's two counsel. There's the receiver's counsel. So there's an attorney who represents the receiver in the case in Nevada. And then there's a corporate attorney who's involved in trying to clean up GTII. So kind of two sets of attorneys. And then there's our attorney who brought the action in Nevada. So three separate attorneys. So I have communication with, obviously, the attorneys in Nevada. I have communication with the receiver's attorney. And today, I reached out to the corporate attorney, and I'm waiting for a return call because I have a specific question to ask him. So the second report is out. So that means that since the receiver has been involved, and I think it's about 60 days or so that he's been involved. I don't know how long the investigation actually has been. It's been less than that. He's generated a couple of reports. And the litigation that's ongoing in Nevada is now, in effect, going to stay. So there's no need to pursue it at this point in time and waste money, basically wasting shareholder money, because we've gotten kind of what we need to now finish the investigation to ascertain what is available, what needs to be sought out. And this is the second interim report. There's another hearing the beginning of January. I would expect probably a third interim report. And and I don't know, by the way, so I'm kind of speculating here in terms of time frame beyond the January time frame. I kind of guesstimated, from now, maybe 6 months or so till he gets through everything he needs to get through. Now, that doesn't mean that the circumstances of the company don't change, because they may change within that period of time. But I'm talking about when the receiver is done. It could be June of 2026. I don't know. And usually that's really significant because generally when you have a receiver, they're getting paid monthly and the bills are large generally. So, if they're working on typically what happens, you have like an attorney, and the attorney, that's their job. They're acting as a receiver. They're charging per hour, per month, and they hire their law firm to do the legal. So they're making a boatload of money. I've seen them I've done receiverships, and I've seen receiverships, and the receivers are making $30,000-$40,000 a month just on their own fees. So the benefit, again, of the way this is structured, I think it's a benefit. The way this is structured, as opposed to those fees going out, and there's not that there's not costs, because there are, because like I said, the receiver has legal fees, but the receiver only gets paid if they recover money and assets. And so, again, I believe, and this is just my opinion and observation, that this particular receiver, Mr. Strickland, really wants to be diligent and is acting as such. And since his interests are aligned with ours, I feel comfortable with that arrangement. And counsel in Vegas also. I mean, I'm repeating what they said. In fact, they were really impressed with the diligence of Mr. Strickland. So that's where we go. So this is the second report. It's really long, and I'm kind of going to go through it starting now. So I'm just going to highlight some areas of interest. If you actually want to read it, I think I sent it to JR. Maybe JR can post it on Twitter if he can, or you can go to the court site and look, pull the document up yourself. I'm going to give you kind of the highlights. They're not going to discuss everything, but these things I thought were the most relevant at this time and ongoing. So, and again, you interrupt me anytime you think, JR, by the way. And
Sure.
By the way, and obviously before I started, I also addressed Alpine. So I looked, before we started, I looked at the Alpine to see the status of the appeal in DC, and nothing has been done on that appeal. It's still pending. I know JR thinks that there might be a Supreme Court case coming that maybe they know about, that they're waiting on. Otherwise, I just think they're being very, let's use the term, deliberate in their decision and being very slow, unfortunately for us. The other matter in Utah, someone Susie sent me something that there was a filing reflecting that they say by the end of December, they're going to issue a ruling with regard to the request for the stay in the Utah action. We'll see. We'll see what happens. We'll see if there's not an extension of that stay request. Again, I don't understand, JR, do you have any understanding, again, what the logic is at this point in time of doing this? The SEC, well, somebody told me the SEC is not doing any prosecutions or anything subsequent to October 31st. I guess because of the election, they're kind of on hold. But can you give me any rationale, knowing what you know, why just letting Alpine, who's like, it's like the emperor with no clothes. It's not like they haven't been disclosed publicly. Why did they just continue to let this go forward without doing anything?
I don't know why. It's an odd thing for me to get my head around, to be honest with you. I mean, this has been going on now for almost 2 years. I can't think of any reason why they haven't expelled them already. I mean, the problem they have now is they can't because of the injunction. But why did they let it get this far after the 34,000 violations of the cease and desist order? What the fuck were they doing? I mean, and we've talked about this. The SEC and FINRA are lax when it comes to enforcing the rules against these institutions. I mean, the one thing that and I was talking to someone about this the other day, they want to be more transparent. They keep talking about transparency. Well, if you go through all of these fines and all of these, violations, the one thing that you don't see is what's the ticker that was impacted, when an institution doesn't mark a long as a short,
Right,
and vice versa, or something like that. They cost investors $1 billion. Well, what investors did they cost $1 billion? And you should be putting that ticker out there, and then we should have the right to go. Well, we do have the right, but we don't have the information to do it. We should have access to that information to turn around and sue these guys. That's the only way that kind of stuff is going to stop. There's no consequences for the wrongdoing. It's a cost of doing business, and because there's no transparency, they don't give a shit.
You're right about that. So and I'm just using this, I'm picking a name out of the hat. If Merrill Lynch, they still in business? If they get fined $50 billion for improper trading practices, they just get fined. Nothing is disclosed to the public as to the companies they did improper trading practices with. So there's no way so maybe somebody gets some amount of money. And by the way, $50 billion fine will never be the case, but some amount of money goes to fund the agency, and the public gets nothing. right? I mean, I think that's the way it goes, right? The money they
where the money
collect,
goes. That's
the
assuming they
fines.
collect the money.
Yeah, I know. To the extent they even chase after the money, because they don't do that either. But to the extent they do, it funds their budget, and the public doesn't get any benefit out of that. No,
No,
it's absurd. But the thing that makes Alpine, and again, Alpine's a prime broker that was purportedly had a concentrated short position connected to GTII. What makes this kind of unique is this is not a question about there being a dispute of misconduct, right? We have 40 years, and I
right.
bet you I could call, probably 40 witnesses from the SEC and FINRA who would acknowledge that they've had multiple acts of misconduct, but still as of today, nothing's happened. It just kind of is confusing. It really is confusing. Nobody's ever explained it. And it really suggests at best, if I'm going to give it the best kind of intent, incompetence. That's the best scenario for them.
For sure.
Yeah.
And keep in mind the case that's in front of the district court isn't on the merits.
No.
They're not arguing the merits. They're arguing that FINRA is unconstitutional and can't discipline them.
Yeah, I know.
So they're not saying, "Oh, we didn't do this." Yeah. No, that's not what they're saying.
Yeah, and again, they're not at the end. So
no,
there's legal maneuvers to the extent that the SEC wants to let it go. There's legal maneuvers that can be undertaken to do that. And they will do it, I assume, if they're spending all that kind of money now. I presume they're going to keep on spending the money.
Well, it's been successful. This has been going on now for almost 2 years. So why not?
Yeah, either they're, my speculation is either it's very profitable at this point in time, or else it's the reverse. It's a way of keeping access to certain information that they may not want disclosed. Usually, it's probably one or the other, or it could be a combination. But that's usually how it goes. That was kind of like how it worked with GTII. It was kind of, either they're not very good or they're beyond not very good. One or the other. Right. I think it turned out, unfortunately, they were beyond not very good. But that's subject
to a different story.
Yeah, and that's subject to obviously what a court determines. So the action, kind of getting back to finishing up with Alpine. So I don't think anything in the near term is going to happen. It doesn't give me any belief that just because the SEC says they'll get the stay issue completed in Utah by the end of the year, that they can extend again and again. Not trying to be Debbie Downer here, but what's going to happen is there'll be an appeal. It's not going to be it's not the concluding chapter. So what really needs to be happen, and we've been talking about this how long? How many times? The case would have been over,
July
by the way.
Of 2022.
The case would have been over. It would be maybe up on appeal. What I said and what JR concurred in, they had the ability at all times to go to federal court. And whatever they wanted to do to Alpine, they could have done it in federal court. What they were doing, and it's interesting in light of what happened, what they were doing is they didn't want to acknowledge the fact that they were giving up some power. And if they went right to the courts, then in effect, because they have their own internal judicial system, if they kind of ignore their own internal judicial system, their concern was they were giving up power. And subsequent to that, right, we had a bunch of cases involving regulatory bodies that took power away from the regulatory bodies. So it's just kind of, the irony was they obviously saw it. They must have known the cases that were going to go up also at that time, or speculated the cases that were going to go up. They probably speculated on how the court was going to go.
Well, if you remember at the time, we weren't even what was in front of it. We were assuming it was going to be the normal process. And lo and behold, here comes Jarkessi. And I mean, Jarkessi was big when it comes to 10b-5 claims and fraud claims that they can prosecute. So
yeah, what's amazing in the we're going to talk about it, but in Doge, so that's that agency, non-agency that we were talking about it.
Right.
Vivek in his and I haven't read the entirety of it, but I did somebody else's live stream, and they were reading it to me. So the two cases, so what he cited in support of having that agency, Looper and Jerkesi. So it was kind of funny. I took the opposite position. I thought it was the opposite way, but
I'm not, when I say this, I'm not against what Trump is doing, but from a legal standpoint, they have an uphill battle. I mean, Loper and Jerkesi don't provide any level of support for creating an ad hoc agency that's not pursuant to some type of statutory authority. I mean, it's a huge violation of the Constitution, and on day one they will have lawsuits from every which way you can possibly think of. They have to go about this the right way. So
yeah, I'm a fan of the Constitution, so I'm pro-Constitution. So I know that a lot of people, unfortunately, this is kind of how people work. If something's in their benefit or they favor it, they try to find a way to kind of wiggle around it. And I just think that if you're going to do something, why not just do it correctly the way you know you can have it done? This, especially in the case if the Republicans have both the House and the Senate and the presidency, this is not a case where they can't get done what they want to get done, at least for 2 years. And so I don't think there's any excuse for taking the shortcut. I think it's the opposite.
No, I don't either.
Yeah. So, and we'll talk about it more in depth. We can explain kind of, because we had talked about this earlier, since they brought it up, and since we talked about Looper, Jerkesi like ad nauseum, we did a bunch of videos on it. We can go talk about it in that context. But now
we can actually talk about it intelligently.
Well, I don't know about that, but we can certainly talk about it. At least maybe one of us combined. Maybe combined.
I can. I'll speak for myself. I can.
Okay. Yeah. At least one of us can. So now I'm going to kind of quickly go through portions of the report. Let JR comment where he thinks it's, important. So the primary goal is to identify, locate, secure, and I'm reading from the report. So whatever, from this point in time, I'm not editorializing. I'm just reading from the second interim report that was filed with the court.
Okay, just two comments. Number one, I'm looking at my phone because that's where I have it. Just so you know, that's why I'm looking over. And number two, I don't know how to post this thing on Twitter, folks. Sorry, I tried when Richard was talking earlier, and I don't know how to post a PDF on Twitter. So sorry.
Okay. Well, if anybody give him advice,
somebody wants to explain it to me step by step in the comments, I'll take care of it.
Okay, so now I'm reading from the report, and except when I say I'm not reading from the report, I'm reading from the report. So the primary goal has been to identify, locate, secure, and stabilize the receivership assets in order to preserve their value. A secondary goal has been to work towards completing the company's audit and bring the company back into compliance with the SEC reporting guidelines. We'll stop there. Now I'm off report. So what my understanding is that their hope is that the audit will be complete by the end of this month.
Right.
They have, so at best, I guess there were some outstanding issues, and obviously because of the change in management, there was a difficulty in getting cooperation. But I guess they have now supplied, and again, I'm not involved in the process, so I don't know, but this is my understanding. I guess they've supplied the auditor what they need. They're now waiting for some determinations or how to characterize certain events, and then the audit will be completed. So that will be done. I'm told the end of November. Is that a guarantee? No, because things fall. And if it doesn't happen the end of November, it might be January, because then we have December. Right. Just being realistic. I don't know anything, but I'm just being realistic, kind of having seen things in the past. But we're close to having the audit done. And then once the audit's done, and this is something I'm going to read, one of the reasons I called the corporate attorney, once the audit is done and they're SEC compliant, then we get the issue about being, trying to get it relisted, et cetera, and being tradable. So when I mentioned that, it might be June before the receiver finishes all his investigation, gets back whatever he needs to, makes whatever legal decisions are necessary, that things can still change. So to the extent that the audit's done and to the extent that the company is relisted or uplisted, that can all happen before the receiver's final report. So I know people ask me when things will be done and when it's going to be traded. I have no idea, honestly. But I'm kind of giving you like my best guesstimate of the outside ranges in my mind, but they're just guesstimates. It's not like I made up the information. I would always like run it by somebody just to see if they agreed that it was a reasonable estimate. So this is something like I ran by our counsel, just guesstimating kind of time frame. But in the meantime, they're trying to get, whatever they can get. So that relates to the secondary goal of the audit. So the audit hopefully will be done by the end of November, and then they will be in compliance with the SEC reporting guidelines, and that obviously is an important and necessary issue before it can be tradable. And then again, once I find out from the corporate counsel what that entails, I will let you know that also.
Right.
The last part is to identify, and now I'm reading from the report again, identifying and understanding the waste and possible misappropriation of company assets and resources. My third goal is to investigate possible wrongdoing of the former officers and directors, including friends and family involved in GTII's business or stock transfers or sales. So those are kind of the main goals. He's obviously already started this, and now let's get into kind of some of the meat or the points that I found interesting. So there's a summary, and now I'm referring, if you ever get to this report, I'm referring to page 3 of 53, where I'm talking about now. And it's near the bottom, starting with line 21. And it's kind of a summary of, to date, what they've been able to recoup. And in total, it's a little under $475,000 and a little over 15 million shares of stock have been recouped. And that's separate and apart from those canceled shares. We all remember there was like 36 million shares that were canceled. These are another 15 million shares that were returned. And the money is described. Where did they get the 474? They got 74,000, and I'm just giving you round numbers. 74,000 from some attorneys. I don't know who these attorneys are, by the way. Some attorney's trust account. $300,000 from another attorney's trust account. Now, this attorney, this is interesting, I think. This attorney, it's called Alpine and Associates. This is somebody who reached out to me as a shareholder in or about February, March of 2024, when I was threatening to go postal. I'm using that term jokingly, but I was saying, there seemed to be something afoul. There was something amiss here. And he's somebody who reached out. He didn't say he was representing GTII, but he was a shareholder, and he tried to say, hold off, they're going to, things are going to work out. I guess they didn't work out exactly as it happened. So, but apparently he received $300,000 as, I don't know, as a potential retainer. Let's assume, for the sake of discussion, it was a potential retainer. It was found out, and that, by the way, that $300,000 retainer was transferred the day of the minute order of the court in Nevada ordering the receiver. Now, some people might say that timing might be suspicious, that it was an act after the receiver had been appointed, and maybe they shouldn't have transferred the money because the minute order said you can't transfer money. But maybe I'm being too critical in my analysis. But
it was transferred. Wait, okay, now I'm waiting. It was transferred to the attorney the day the minute order came out?
Yeah. Yeah. So, again, you might think that somebody's acting in response to the result in the court, and they were trying to have a pot. And again, I don't know. I'm just saying what it looks like, and somebody might suspect, and I think it would be a reasonable conclusion, that the money that was sent to be used for future legal purposes. It came out of GTII's bank account, which should concern all GTII investors. But the receiver contacted the law firm. I guess they were encouraged, and they did return the $300,000. So that's part of that that money. 100 grand was received from Warren Markowitz, and Warren Markowitz, I believe, although I'm not certain, at one point in time, he was an attorney affiliated with GTII. I don't know if he was general counsel. I don't know if he was like attorney for just limited purposes. But at some point in time, some $100,000 was recouped from that. 9,000.
That was the same day too, by the way.
Yeah. So again, some people might suspect that's not a coincidence. And maybe that's why also they returned the money. Because, if you're involved in and again, I don't know this to be a fact because I wasn't there and I don't know. But I can imagine, let's say I'm involved in a naughty transaction and somebody calls me up that has some legal authority and they say, we caught you in a naughty transaction. Will you return the money? That's when you probably say yes. And they said yes. So they must have identified the fact that it was somewhat problematic. Apparently, there's a loan that's owed from Astra Energy. And I don't think Astra Energy, we did a video on those, right?
Yeah, we did a video with him.
Yeah, that was I don't remember when that was. When was that?
That was a while ago.
It was a long time ago. And there was no discussion. That's interesting. There was no reference to GTII, right? We had no idea he had any connection to GTII.
No, it doesn't say when the loan was made.
Yeah, I guess it could be done more recent, I guess. But we wouldn't have had any interest in GTI related to him anyway at the time.
Well, they defaulted on it effective February 16, 2024.
That would have been after that would have been after we did our thing.
Oh, yeah. Oh, for sure. It would have been after, but he would have had to have had the loan at the time.
He would have, but we wouldn't have asked him about it.
No, but wouldn't that have been reported on the financial statements? Should have been.
Maybe, but listen, we know that maybe not all auditors are really 100%, right?
True.
Did you hear, by the way, that SMCI, so that was a supplier of chips to NVIDIA, they got their auditor said, we can't, and it was Ernst & Young, I believe. Their auditor said, because we've been there with Borgers, their auditor said, we can't sign off. We got to leave. And
they're getting delisted here in a couple of days.
Their stock was at 120 and now it's at 15, maybe. And that's been like a straight kibosh. Their earnings weren't that long ago. They crashed. I mean, you can imagine, now we know, if your auditor splits and if your auditor says, we can't really trust you, that's a problem. And there was a short report, the Hindenburg put out a short report about their financials about a month before. And, they denied, the management denied there was any validity to the short report. But apparently there was some validity to the short report.
Well, those guys aren't wrong all the time, and they're not complete 100% fucking liars either. I mean, you probably have some decent people in there doing real work and producing real information. Obviously, they were spot on a month before. My guess is they had a contact in the auditor's office that shared information they weren't supposed to.
Very possible. Very possible. I don't know. It's just interesting because again, we're talking about GTII, and GTII had Borgers, and Borgers was an auditor that got basically squashed. We're looking on the other side. This is the auditor saying goodbye. Maybe that's what the auditor should have said with GTII. And if you recall, it kind of happened, right? Because before Borgers was appointed, that prior auditor said, we're not going to renew our engagement. And, it's a business. And the fact that they're not willing to renew their engagement is suggestive, if nothing else.
I'm gonna tinfoil here because I think NVIDIA is the next Enron. I really do. They are reporting their financials the exact same way Enron did. Everybody loves this company, just like and I remember Enron because it was a big deal when Enron went down. It was a big fucking deal.
It was
and
huge.
all the hype that was around it. I remember watching the TV and watching these people walk out of their offices with boxes crying because they had lost, they had a stock buy program for their employees. Well, as you know, the stock was just charging and charging and charging and charging, and all these people were just buying into it, had their life savings into it. That was one of the reasons, I forget what the act was, that basically said, look, you have to have certain safeguards in place if you're allowing your employees to purchase your company stock through their 401k plan, because that was permitted at the time. And that's part of what was happening. It was part of why all their employees lost so much money, because they were buying the stock through their 401k plans, and people got wiped out.
So JR's recommendation, this is a financial recommendation.
No, it's not. I
said
it was tinfoil, my opinion.
But if your tinfoil recommendation would be short NVIDIA, right?
No, I wouldn't recommend to short anything right now. I don't own NVIDIA. I'm not shorting NVIDIA. I just am paying very close attention to it because I'm just having flashbacks to the Enron days.
Well, if you turn out to be correct, that would be like really amazing. I'll give you credit.
It'd be a first time.
Right, that's true. That's true. And also, you wouldn't be investing in it, so you get like the same gain, right? A zero gain. Yeah. It's just interesting though. So apparently, there's a debt owed from Astra. This is going back to the report. There's a debt owed from Astra. They've apparently made an offer of $225,000, but they don't have the money yet. So I guess they're waiting to see when that can be returned.
Right.
And that's in the report also. The receiver also went and checked the main account for GTII. I guess it's the operating account, and there was a bunch of credit cards and all kinds of stuff. And the receiver is doing. I didn't mention it, but there's like 10 credit cards, and the receiver is analyzing, and has a forensic accountant analyzing if these were company expenses that were reimbursed or these personal expenses. I think he suspected, I can't speak for him, but I think he suspected that at least some of them might be deemed to be personal expenses, and to the extent they were charged on company cards, that they then are assets of the company. And I think that's one of the things that he's evaluating also. But he got access to the TD account, and I guess it took a little while. And the TD account apparently has about $151,000 in it right now. He has an appointment on November 21st, which is about a week away or so. Yeah, exactly a week away, to go and get the money. So that money will be obtained. That's in addition to the monies that we mentioned before. He recovered 14 million. So I mentioned it was like about 15 million shares that he recovered. Of that, 14,850,000 shares came from a company named Internet Capital, which was an entity controlled by Warren Markowitz. Mr. Markowitz, again, was that attorney we mentioned before that had some affiliation. I don't know what the specific affiliation was with GTII. I don't know why he received those shares. And you will see that's an issue that the receiver raises quite a bit in this report. The number of people who got shares, and he doesn't know why they got shares. It's impossible to tell.
Right.
So there's also, so the receiver recovered 14,850,000 shares from Internet Capital and 275,000 shares issued to Cedars-Sinai Medical Center. You will see, and if you recall, there were a bunch of shares issued to foundations and charities, etc. Why? I don't know. Really, it's hard to figure out a company that has zero revenue, and I think that's what the receiver kind of is referencing. A company zero revenue giving away shares, it's confusing at best.
No, man, let's just call it. It's fucking criminal. I mean, I just read line 11 in the subsequent email. Jesus Christ. These guys are fucking crooks.
I'm not going to say that. And obviously, it's just JR's opinion. We don't know, whatever. But, what JR has said, other people have said that to me also. So it's not like, it just kind of looks, either the facts are different than what are disclosed here. It's possible. Or if they're not, it's tough to rationalize, a bunch, maybe one or two events, but if you got like 20 or 30 events, at some point in time, it's hard to say it's a mistake or there's not intent or whatever.
Here's the other thing. I want people to understand this. This was a report that was drafted by someone that was appointed by the court, the state court in Nevada, that's going to be read by a judge.
Yep.
So this guy's not making bullshit up. He's reporting the facts as he's finding them. These are the facts. This is not made up bullshit. It's for real.
There was a hearing yesterday, and it was a motion filed. I think a motion to dismiss, in my opinion, some BS motion, and the court hasn't made a decision yet. But during the and I had a conversation with our Las Vegas counsel about this. When the judge who made the decision to appoint the receiver, when he did it, he didn't have these first two reports.
Right.
What I was told yesterday when I was speaking to the attorney, he really felt much more confident, the judge, and happy in the appointment of the receiver, kind of like what you're saying, what your comments are referencing. And again, that's just opinion. We don't know, in terms of the legalities of what went on and intent, we don't know that.
So I, folks, I really wish I would have had the time to read this. My plan was to read it before we had our live stream at 10:50. So I'm reading this as we're going through, but I want to talk about number 11. Come on, man, please.
Well, we haven't quite got there yet.
All right. Well, yeah. Well, all right. Keep going. Keep rolling.
Okay. So, but we're evaluating conduct. So kind of what we're doing here is we're looking at entries and comments by the receiver, and then how do you evaluate that, and could you justify it? And some of these items, and JR is talking about number 11, some of these items are hard to justify. Just like, when we were talking about one of the issues was the furniture, right? There was a bunch of meeting expenses that were charged, apparently $35,000 or something like that. Not that that's the biggest number. I mean, it's a big number, but it's not the biggest number in the world. But the company had no space. So how do you justify having furniture with no space? That's a tough one to justify. How do you do that? So,
well, the furniture went somewhere.
It must have. So number 9, I'm on number 9, by the way. So the forensic accountant went back and looked at and found a trust account that has $1.6 million approximately in it. And now I'm kind of summarizing as opposed to reading directly from the report, but somehow the receiver determined that there was some kind of, he thinks, not his terms, but he thinks there was some kind of shenanigans going on. And the $1.6 million really should be money that belongs to GTII. Is that a fair summary?
Just fucking read the sentence. It's
which
so
sentence?
Much better if you just read the sentence.
I'll let you read it. Read what you see.
This is line 9. The receiver's forensic accountant has identified approximately $1,631,768 plus interest in a trust account. Mr. Scott Wirtz of Rock Mountain Financial Services was the trustee of Punalonis Holdings Trust, the entity holding the funds. The funds, this is the key sentence here. The funds are the proceeds from an opaque stock loan scheme that Mr. Reichman and others pursued on behalf of the company in June of 2023. So what that says is it was a loan, but we can't find the terms of the loan, and we don't know what the loan was for.
Yeah, so that's
what it means.
That's pretty bold statement by the receiver there, because he's determined it's a stock loan scheme. I don't know how you read that as a positive transaction.
No, you don't.
No, you
I
don't.
think he's being diplomatically correct here. By phrasing it that way.
Yeah, I think so. And so he says, he was in contact with the trustee. The trustee then got removed. And so this is now my interpretation. So somebody got nailed. Now they're trying to dick around And
Oh, and by the way, Mr. Wirtz resigned from that
yeah,
position, is no longer responding to the
yeah,
receiver.
yeah, yeah. So it may be the case that the receiver has to take active legal action against these guys directly. And, you know, and I am going to, one of the things I'm going to do is where I think that they need to, and again, I have no control or power or sway, but like this, for example, $1.6 million, definitely worth going after. And I'm going to suggest to the Receivers Council, file an action, go after it right away, because that's a lot of money. That's not like money that $1.6 million is not insignificant cash. So some of these items I'm going to suggest action. They may do whatever they think's, you know, best interest, because there's costs to be considered, legal fees, etc. But like this one in particular, if the receiver is already determined it's a scheme and the money really belongs to the company, then there's no reason not to go after that. Number 11. Why don't you could read that one?
The receiver has identified a 2024 Land Range Rover Sport VIN number, I'm not going to read that was purchased and paid for in full on November 8th, 2023 by Mr. Reichman and treated as a company expense in the amount of $147,318.05. In the following email from to Mr. Reichman and Miss Kathy Griffin, a company accountant informs how the Range Rover purchase quote would disappear.
Do you find that language problematic?
Listen, folks, listen. Anytime someone is talking to you on a corporate level and they're insinuating, implying, or flat out telling you that they can make the money disappear, it's a fucking problem. Okay. I can say that firsthand because I had to work every year annually, because I oversaw the retirement plans. I had to answer a fraud review, and it was about 100 questions, and I had to go through every question, yes or no, yes or no. And that's the type of question they were asking. Has anyone ever implied this? Has anyone ever asked you to do that? Those types of things. This right here leads me to believe that there was a significant amount of fraud going on in this organization.
Yeah. Again, your speculation. You don't know. You're correct.
I am.
Yeah.
Yeah. Oh, it's for sure speculation. But now that I'm reading this, folks, I'm going to do what I can to get this posted. Okay. So, I'm going to figure out how to post this on Twitter so that the general public can read this.
I mean, again, you know, if everything that's stated here turns out to be accurate, it looks outrageous, and it continues. And again, you know, we're looking at now page 6 of 53 of this page report. We're on page 6, by the way. Just think about that. Page 6 of the 53-page report. In it, it has reference to what the auditor suggested. And number 2, it says, and I'm reading from the report, page 6, line 6, the car purchase about $150K. I just buried in the profit and loss items. Now, some people might say that's concerning language. Maybe that's like term of art. Maybe that's not really meaning what it says. You know, it might have a different meaning, but it certainly sounds suspicious. They could have used didn't have to use such a dramatic term. And it would also be hard to justify the expense. What did the company need that vehicle for?
They didn't.
I mean,
maybe they're the office the office furniture or in a trailer attached to the Land Rover.
It's in the vehicle. Yeah, that's right. Maybe it's in the vehicle. Yeah, but it's hard to see how that would be.
Do Land Rovers cost that much? Is that what an average Land Rover is? A brand new Land Rover? Does anybody in the comments know?
It might be pretty juiced up. You know, it might be like all the features. Listen, if the company's paying for it, right? You might as well go all out. I got to give them credit for that.
Sure, no one's going to get caught here.
No, although November 8th is
okay. So someone just said yes, they paid $106,000 for theirs. So I guess that is an average cost.
Now, November 8th was not. I certainly wasn't like actively doing anything. but there were questions. But it's interesting. The timing's interesting of that particular purchase.
No,
Again,
no, you're right. Well, we weren't actively doing anything against the company, but
yeah,
remember, July 23 is when we started reviewing the legal proceedings that were being taken against Alpine.
Alpine, right. But that could be seen as pro company, right?
Sure, sure.
Yeah. It's just interesting because that's a big expenditure again at a time. Let's just focus on it. At a time, what was the revenue of the company in 2023?
Fucking zero.
Zero. And what was the revenue of the company in 2022?
I wonder how they line item that on their financials. We should go back and look at the 2023 financials to see where that's line item.
Well, he says he buried it, right? I mean, the auditor said he did. So I don't know. Maybe that would, I would guess, that in the audit that they're doing now.
Oh, he buried it in the profit and loss item.
Yeah, so I'm assuming that in the audit that maybe that can be figured out in the audit.
Oh, I didn't think you would want it showing as a depreciable asset popping out on the balance sheet. The other option is to offset the additional salary. Think about it.
Yeah.
Here's a nice one. Kathy, your salary accrual to the beginning of this year was $207,500. But I picked up the number just next to it, which was 275. Sorry for my mistake. These are great fucking auditors.
That's Borgers. That's Borgers.
Jesus Christ.
Somebody asked, somebody was saying that they didn't feel better. I kind of look at it differently because I see as, wow, there are so many potential assets that might be able to be recouped and shares that literally, a lot of people think that sometimes companies aren't revivable because there's no assets to get revived. And in this case, to me, there is.
Sure.
Besides the fact that, like there were 36 million shares canceled. He just got back 15 million. I'm guessing that 15 million is not the end of the road. There may be a lot. And if subject to whatever the real share count is, because we really don't know what the real share count is, but subject to the real share count, the actual share count shown, if you get back, like 150 million shares, that's not insignificant. That's a significant drop down. So the fact that I look at it, the fact that these shenanigans may have gone on, and if this stuff is true, it happened. But I think of it as a possible, like, it's a gift horse because we have an opportunity to get all this money back or get a portion of it back. Because it may not be the case that all this stuff is retrievable, or it may not be financially possible, but he got $500,000. There's 1.6. He's picking up $150,000. There's going to be an issue about the difference. There's another 2 million we'll get to. There's a lot of money that can be recaptured, whether it's all recaptured or not. So I wouldn't feel bad about the report. And I wouldn't feel bad if you feel like you didn't do a great job doing your investigative work prior to buying the shares. Because listen, you'd have to been a forensic accountant and have access to all this stuff to know.
Well, so I'm going to make two comments to that. Number one, I mean, I'm going to speak for myself here. I bought into this for the short squeeze. I knew the company really wasn't engaged in any partnerships or anything like that. I fully bought into it for a short squeeze. I didn't hold that many shares, and I have a very low cost basis. So from my perspective, it's not a big deal. But here's the thing: you're not giving. I gave you kudos before, but you're not giving yourself enough credit. There was no way to do this level of due diligence. But had you not started pushing this rock down the hill, Richard, we would not be sitting where we're at right now. I mean, the fact that we're going through this report and picking things apart and seeing things that we never would have saw a year and a half ago is pretty significant. And I'm going to say it again. A lot of it has to do with your tenacity in moving this forward with the attorneys and the right people and getting in Reichman's and the board's face.
I appreciate it. Again, it was like a team. I had this. It's funny. I had a discussion yesterday with the attorney, and it's a lot of things. A lot of different people having the resources to have a law firm pursue it, because just to have that, there were people that put up legal fees.
Right.
how often is that the case where somebody's going to do that? That takes. And then I thought the lawyers in Nevada did a great job, and it was a bunch of things. So I appreciate the compliment. I feel good about it, by the way. I feel good that I
You should.
advanced the ball, and that my intuition was correct. I didn't know what it was.
Well, here's the bottom line. If this thing can trade again, and I'm not suggesting that's going to happen anytime soon, but if it can trade again and people can recoup some of what they lost, that's good work. I'm not suggesting anybody's going to get what they put into this. I have no idea. But if people can at least get some of their money back, I think that's a win.
Yeah, I agree. Because I think the company was going to be dead otherwise. It looked like it was on a death door.
Yeah.
And there may have been reason why people wanted it that way.
Right.
But yeah, it'd be great if people can get money out of it. That's the bottom line, to get it back.
Let me answer one question, Brett.
Sure.
Montgomery. No, I did not post it, and I don't know how. So if you know how to post it on Twitter, it's a PDF in my email. If you know how to post it, put directions in the comments. I gotta figure that out, and that's gonna take me some time.
Okay. So next item that caught my attention were the proceeds from warrant sales. So in 2022, there was
I saw that too.
3.275 million in warrant sales that were transferred to the transfer agent, Liberty Stock Transfer. Is Liberty Stock Transfer? No, it's a different one. To GTI's bank account in October of 2022. The receiver wants to know what happened to those funds. Where did they go? Again, I don't know what the company was spending money on, in 2023 to do what? I know they spent a lot of money on paper, but didn't seem to accomplish a lot.
I have an idea where 147,000 went.
We know that. So another item they're investigating is the ownership of a condominium on Wilshire Boulevard in Los Angeles, which I'm familiar with that area.
Hold on, Brett. I mispronounced that company's name. It is not Muzama. I'm terrible with pronunciations, but I know that that's not the same. It's not the same company that you're talking about. Sorry, go ahead.
No problem. There's a condominium in West LA, not far from UCLA. It's a nice area of town, and there's a question of where the funds came for that ownership. And that condo, I looked on Zillow before today just to get a ballpark. It says it's worth about 1.4 million. Then there's a residence in Larkspur, California, which I think, although I'm not sure, is in Marin County. That's also subject to being. There's an issue about the source of the funds for that also. That residence is worth $2.7 million. There was that bracelet that was found and some other stuff. But that's a lot of money in just those particular items. Whether
Jesus Christ.
Which part?
They charged the bracelet as a meeting expense.
Yes. It's a goodie bag. It's a nice goodie bag. Yeah, I know. It's not a big item. It's just kind of ballsy that you would do that. It's a Cartier bracelet. It was worth like $8,000, charged as a meeting expense. Again, sounds a little hoary to me. A little bit. There's, again, in small companies, often people do overreach, and it happens. It's a matter of how far the overreach is. And again, I think in this particular situation, the bottom line is nobody thought anybody was going to be checking on them, and it turned out otherwise. So,
whoopsie.
Yeah, I know. So part of the report, now we're on page 10, by the way, it talks about excessive expenditures, and the receiver looked at that balance. So he went back. There was a balance in that TD account that we mentioned as of January 1, 2024. As of January 1, 2024, and not long thereafter, I was on their butt. And I wasn't probably the only one. As of January 1, there's $1 million in that account. There's now 151,000 in that account. That means they spent, kind of knowing, I would think, at least part of the time they knew that they were under scrutiny, and they still spent, close to like $900,000 on, again, in 2024. 2024 now we're talking about 2024. I don't know what they've done. Maybe they spent some money on accounting fees. That might be a legitimate expense. Legal fees, I guess. $900,000 seems like a lot.
Dude,
And
they made a $38,000 credit card payment in September.
yeah,
that was just 2 months ago.
I know. Again, there's explanations, but this is long after there's even we're in court at that point in time. We're not talking about that there might be a problem. Everybody's on notice. There's a receiver. The receiver was already in place, and they're still paying money out from the account. That, theoretically, if you're violating the court order, that's contempt, right? In the best case scenario, explain that. How do you not know? How do you not know to spend company assets when there's a receivership order in place? And this is not the minute order, it's a final order. And they're spending money. It looks like drunken sailors. I don't know what the point was, kind of what the receiver says. And again, we're talking about on page 10 of 53 of the report, excessive expenditures.
Yeah.
But the receiver is wondering, what are they spending money on? And if they're spending money using the corporate account, that stuff is the companies, not the individuals. And it's suggestive that it's used for personal purposes, not for company purposes. But it all smells. It smells bad. And again, if
it smells bad on page 10, page 11 fucking stinks, man.
But I mean, that's done with under scrutiny. So that's not done with not knowing that you're being watched. All that is done while you're being watched. And they still had the huevos rancheros to do that.
They seem
surprising.
To like to classify things as travel expense or office expenses or meeting expense, because
I have to come clean about that.
This is like a fucking book on how not to run a corporation. That's how bad this is.
So the receiver concludes they were spending about $100,000 a month from that account during 2024. Doing what? I have no idea, other than again, might have been some accounting, might have been some legal, maybe there's some other expenses, but I can't imagine spending that much doing nothing, really. Now, I have to apologize. My understanding was that he was living at the Beverly Hills Hotel, and I was wrong, apparently, according to the receiver. So I have to apologize. I accused him of living at the Beverly Hills Hotel. I was in error. Apparently, it was the Beverly Hilton Hotel. So that was the correct name. And one of the items they caught was there's a couple of, and again, this is just a couple of items. This is not the audit. So that audit that's being done, can you imagine what that's going to come up with?
Oh, I'm sure.
This is like the forensic accountant of the receiver, kind of just looking and pulling up some stuff as it goes along. So there's a couple entries in October. Yeah, that's unusual. I don't know how you characterize this. I didn't even realize it was this bad. So October 6th, there's a charge at the Hilton Beverly Hills Hotel for $11,481. Maybe that's a bunch of nights, he thought. But then he looks at the next charge. October 7th, Beverly Hilton, a charge of $12,713. I don't think that's a room charge. That seems like that would be a really expensive room, in my opinion. And even though I don't even think that's, by the way, this is my opinion, that's a hotel that's being remodeled because it's kind of run down. But that seems like an excessive charge. Again, I don't know how that's related to the company. And then on top of that, it has a Neiman Marcus charge on the 15th for about $2,500, just under $2,500.
For his daughter.
Yeah.
For his daughter.
it's concerning. That's the receiver concluded, line 12, page 11, that it was for his daughter, and it was charged as a travel expense. I don't know what it is. Could somebody like need a suitcase or something, maybe? But I don't know if
It's
that's
for
a company.
loafers. It's
Yeah,
for loafers.
well,
The banks.
what I'm
Oh,
saying is I don't know. No matter what, I don't see how that's for a company expense. I don't see how that benefits the company or is in the interest of company. And again, it's charges that at best raise a concern about the propriety of the charges and whether they were for the benefit of the company or not. At least they have to be explained away. Kind of what needs to be. And by the way, when I was contacting them and I was sending them emails constantly, that's what I was asking for. And that's one of the reasons that I got annoyed. And one of the reasons why I continue to pursue it is they never responded. And the fact they didn't offer any explanations suggested they didn't have any explanations to offer. That's the only conclusion. So here they are, kind of the same thing as not offering an explanation. So one item that he looks at, and we've mentioned this, but there's a $2 million apparent stock sale involving the company's profit sharing plan. And through that, I'm looking at page 12 of 53, line 16 now. Through that, $1.8 million apparently went from the Markowitz client trust account. And again, Markowitz apparently was an attorney that had some affiliation with GTII, went from his account to Mr. Reichman's account, $1.8 million. Where that is, I don't know. Is that appropriate to make a transaction involving the company's profit sharing plan in the first place? Even if it was legit, I don't know if that's appropriate to use the company's profit sharing plan to pay money to one of the principals. It raises question. It certainly raises question with the receiver. So there's a question about the legitimacy. The receiver is going to pursue that. One of those areas that I mentioned that I'm going to direct the receiver to pursue is that. Again, when you're talking about $1.8 million, $2 million, that's got to be pursued. Whether it can be whether it can be unwound, whether anybody else besides Reichman has liability or potential liability, I don't know, but there are other names that appear there that might have some issues. I don't know, and I don't know whether that's been considered to this point in time. So there's also a distribution. Now I'm looking at I skipped ahead, and I think oh, here we are. It's funny. I stapled this thing 3 times, and I still stapled it out of order myself. I'm on now page 14, paragraph 8, and there it's talking about it was $2 million, 1.8 to Reichman, and apparently $200,000 to Markowitz out of the GTII profit sharing plan trust shares. Again, I'm not a securities lawyer. I'm not an ERISA lawyer. I'm not a Baldwin Hills lawyer.
Let me read something. This is gonna clear it up, but this is gonna make perfect sense to you what was going on.
Okay.
Okay, I'm on item number 10 on page 14.
Okay, I see it.
Okay, Mr. Markowitz, he was an attorney that was the administrator of the profit sharing plan. Mr. Markowitz further states in emails to the receiver, quote, "My involvement as trustee of the profit sharing plan trust. I have taken no action as trustee. I was appointed and accepted the position on behalf of the company," quote, this is him, "but the company failed to provide me the supporting docs in order to act on behalf of the trust. To my knowledge, that authority remains with Mr. Todd from GTII. I have taken no action, nor have I had any authority to act since the appointment." So he was an unknown figurehead. That's what they did. They appointed somebody and they never gave him the information to do what he was supposed to do.
And on page 15, there's kind of a brief summary of the conclusion that the receiver has drawn at this point in time. And again, this is an ongoing investigation. So each time he's identifying items, and to the extent that they can be resolved without litigation, he's going to resolve them. To the extent that they require litigation and he thinks that makes sense to go after him, they'll go after him. But his summary is, and I'm reading from the report, page 15 of 53, line 3 through 6. It appears to the receiver that GTII's former board of directors stood by, and while Mr. Reichman and Warren Markowitz profited from the sale of GTII profit sharing plan trust shares that belong to the company. The receiver believes all assets purchased with proceeds from the stock sale are property of the receivership estate. That's the receivership's conclusion. I don't know, by the way, what the conclusion of the receiver is based upon. I don't know what underlying facts he makes his conclusions are. I don't know what documents he has reviewed. I don't know what his conversations are with his counsel. But that's what he's reflecting in his report. That report goes to the judge, and the judge is gonna review it. If the judge at some point in time finds anything in the report problematic with regard to any issue raised by the receiver, I'm sure the judge will speak up about that. But the question is, should he be using a profit sharing plan for that purpose? And then again, the issue is, should that $2 million, does that belong back into the coffers of the company, or otherwise? Were you going to say something, JR?
No, I'm still reading.
Okay. And then there's a question, and I don't know, but I was going to ask about this. I'm looking at page now 16 of 53, paragraph 5. There it talks about what the fair value of the shares of the plan, that profit sharing plan, was as of the end of December 31st, 2022. It was $35,250,000. Or at the end of 21.
Yeah, it's the end of 21, and it's
it was $35 million.
The fair value, it says it in the preceding couple of sentences, the fair value of the funds is based on the stock price at the time of transfer. So to make that calculation, you'd have to see what the share price was on December 31st, 2022.
Yeah, the bottom line is there's quite a difference between the two. In end of 21, it's 35 million and change. End of 22, it's 2 million and change. Is that all the stock price, or is that reflective of money coming out, like that $2 million?
No, that was the amount. That was the fair market value of the shares when they were transferred to the retirement. We'll call it a retirement plan for simplistic purposes. That was the value of the shares that were transferred to the retirement fund at the time.
Yeah, no, my question was different though. Between those years, that $2 million we just talked about, is that part of that decrease? That 35.
I would suspect so. I would suspect so.
And again, the issue is, are there other issues like this that haven't been, discovered yet? And in the audit that's being done, or this analysis, is that going to come out? And, of course, to the extent that the receiver determines, and I'm going to ask this question also, by the way, but to the extent the receiver determines that those shares or that money went where it should not have gone, and the receiver determines it can be recaptured, then they will try to recapture it, I'm sure. And I will ask specifically about that item also, just to kind of get an idea of that. Items 7 and 8, apparently there's 24 million shares out of that plan. 10 million went to Internet Capital, 14 million went to Todd Chisholm, or an entity controlled by Todd Chisholm, apparently. Or it says an entity associated with Todd Chisholm. I think Todd Chisholm was on the board or an officer director of GTII at one point in time, or could be at this point in time. But the issue is, what about those shares? That's 24 million shares. So that's in addition to the other shares we're going to address briefly coming up. It's in addition to those 30 million shares that were issued in January of 2023, and 36 million were canceled, but 30 million weren't. It's in addition to all the shares that are existing with officers and directors, et cetera. So there's a lot of shares that potentially may or the receiver may attempt to recoup. We just don't know, like, we can't make an analysis of whether they're going to be successful on each one. We'll have to see on a case-by-case basis. But if it turns out that they gave shares to, Manny, Mo, and Jack, and, it's going to be harder for the recipients to justify the receipt unless they did something of value, real value for the company. And, it's unfortunate, but that's the way it is. And the receiver is trying to figure out what's going on. So now there's apparently, and I don't know how this plays out, page 17 of 53. I don't know about this, but there's a reference to a transaction called the Robin Biso transaction. And apparently he was a shareholder, although I don't know. This is what the report, okay. Apparently she was a shareholder and had 12 million shares. She died, and the allegation by the receiver is they tried to do some kind of scheme, at least what appears to me, what the receiver is stating is they tried to undertake a scheme to get those shares. And the person was dead. So when they're trying to acquire the shares, this is after the fact. And I don't know if the receiver believes that those 12 million shares should come back to GTII, or is just making a comment about those shares. I don't know. Because if it's somebody individual's shares, then perhaps that should go to the estate of that individual, not to GTI. But I don't know. From what was written, I was unsure. And again, that's an area that I will ask the receiver about. There's also an entity called .8 that apparently is controlled by either former officers, directors, or friendlies at GTII, or at least that's the allegation. And they got a bunch of shares also. And there's been a request to clean that up and ascertain what the right to keep those shares are. That's an ongoing thing. The conclusion, I think, is that the receiver is suspect about any of those transactions involving .8, and any assets used to purchase anything are the property of the receivership estate. Again, GTII. I think that's going to be the common conclusion. Were you going to say anything? I'm sorry.
No, I'm still trying to figure out this transaction.
Yeah, I know. Some of them are convoluted. Some of them may be intentionally convoluted because they're trying to be difficult and it's hard to unwind. But again, if it's a pattern, it's a pattern. So it almost makes every transaction suspect. There's a bunch of reference to shares, and I didn't really understand it exactly, but Justine Reichman, I believe, is a relative of Mr. Reichman. Apparently she got 8 million plus shares, and then perhaps she got another 8 million shares, but there's an allegation that perhaps she has shares, or somebody has 8 million shares that they shouldn't have. And that's being investigated. I think that's also, there's maybe some connection to some of the real estate that's at issue. Did you want to say something?
No, I'm still reading. Sorry.
Okay. And again, there's a concern, and I think that was the original statement by the receiver, that there's a bunch of transactions that are in question involving friends, family, countrymen, etc. Obviously, we have the 10K and all the issues in the 10K, and this is what the receiver recites, page 44, 53, about the huge increase in losses and the increase in the stock compensation, the increase in the professional expenses with no revenue, and he casts further doubt as to the propriety of those particular issues. Then he talks about, now I'm on page 46 of 53, so I've kind of jumping around. Just by giving, kind of like we've given you a sampling of what's going on here. I think by the sampling, you can understand the bigger picture, that we don't have to go through each and every transaction. You don't have to understand each and every transaction, but there's enough questionable activity here and enough. It's not even a questionable activity. There's conclusions drawn by the receiver.
Yeah.
We've talked about it. Conclusions he's drawn. There's a lot here. One area he talks about is gratuitous stock issuances. So one thing they're concerned about is, why did a bunch of people get stock? And there's a whole bunch of doctors that got stock. Dr. Stephen Freeland apparently got 155,000 shares. Cedars-Sinai, 275,000 shares, but they agreed, I think they agreed to return them. We talked about Dr. Hamali Patel, 320,000 shares. Dr. Daniel Marcus, 320,000 shares. And by the way, the fact that they got the shares, it may not be anything against them in particular. If somebody offered them the shares, I mean, if somebody offers me 320,000 shares of GTII, I would say yes too. So
sure.
I'm not putting it on these people, but there's several people. It's not like it's a huge number, maybe. Well, it still might be 1 million shares in total. And we've got a return of 275. There's been a request to the doctors to return the shares. Not all of them have returned the shares. Now, what's interesting, and she only got 55,000 shares. Now I'm on page 47 of 53. And again, I don't know if this is instead of the masseuse and the mechanic, or this is an addition to the masseuse and the mechanic. Is apparently this particular person reflected on page 47, line 17, is Mr. Reichman's hypnotist. So I don't know if it's a company hypnotist, because I guess if it was a company hypnotist, that would be an okay transaction. But apparently it's Mr. Reichman's hypnotist. She's also got shares, not a big amount of shares, by the way. But again, it's just kind of being a little over the top and not really being super careful and making some outrageous transactions, as the receiver has concluded. They're apparently just continuing on. Mount Sinai, and again, there's a request that these stock shares be returned, and we'll have to see how much these particular entities volunteer the shares, or if there's going to be litigation to get them back. But Mount Sinai Icahn School of Medicine has 4.6 million shares. I don't know why. There's a bunch of doctors there, but we don't know why. According to the December 31st, 2023 10K, there were over 17 million in charitable deductions in 2023, almost 8 million in 2022. With what money? There, again, no revenue. Who was paying for that? I mean, I would think if actual money was being placed or shares given out, that's coming from shareholders, right? What's the other source? Who else is doing that? There's also something called the Hans and Rosie Epstein Memorial Committee, Inc., HRE. They apparently have, it's one of the largest shareholders of GTI, 21 million shares. That's 6.24% of the company as they've calculated. That's second next to Mr. Reichman. The receiver concludes at number 20. So this is page 49 of 53. Number 20, line 22. The receiver believes that Mr. Reichman is direct and exclusive beneficiary of HRE and based that conclusion on the fact that in the October 31, 2023 estate planning materials previously mentioned, Mr. Reichman lists HRE as an estate asset. So the receiver concludes that it's an estate asset because it says it's an estate asset. That's 21 million shares. That's not an insignificant amount, and I'm sure when it was done, it was probably worth a lot more. So that's something that the receiver is certainly going to decide whether to pursue or not. And again, in all these cases, the way the receiver is framed it, there is involvement either with Mr. Reichman or somebody affiliated with Mr. Reichman, or something that raises a question about it. Now I'm looking at page 50, number 15. This talks about another large shareholder. I cannot pronounce this person's name, but they had 11 million shares. And apparently this was, at least this is what the receiver says, this was Mr. Reichman's former romantic partner who had 11 million shares. Now, what that person did, I do not know. What they did to deserve those shares, I don't know. But the receiver is concerned about that issue, and that's why it's raised, and obviously is going to rescue it, going to review that. Apparently, the son of that romantic partner was also given 3 million shares. And again, we don't know what that son did or did not do. On top of that, by the way, do you have anything to add, JR?
No, I'm reading that about that transaction right now.
Okay. On page 51 of 53, number 16, line 14, there's another person referenced who's the 9th largest shareholder of GTII with just under 7 million shares, and he's believed to be a lifelong friend of the Reichman family. So those are big numbers. This is not like we're talking about, 50,000 shares. We're talking about millions upon millions of shares, in addition to the shares that Mr. Reichman has himself and others. And those are all items and assets that the receiver is still investigating. And if he concludes that they are not appropriately retained by that person and that makes sense to proceed, I'm sure they will pursue it. There are other items, but again, those are kind of like the big items, and I think enough to raise questions, certainly raise questions with the receiver. And this is a lot of different information that was in the first interim report, a lot more detail. And I'm presuming in the next report, there'll be more detail and more conclusions and so forth and so on. And again, I will provide my own input to the Receivers Council to tell them what I think, and they may disregard what I say, and that's perfectly fine. They have their own judgment. They're professionals. That's fine. But I will at least make it on record the items that I think they need to pursue, or at least they should consider pursuing, just because of sheer monetary value. And that's kind of basically in terms of my kind of summary of the report. Anything else you want to add, JR?
You want to read this summary on the last page?
I'll let you read it.
Summary. GTII's former directors and officers utilized GTII as a personal piggy bank with the stock as their currency to distribute as they wish to family, close friends, associates, favored entities, and pet projects. The shareholders have paid the price of this massive dilution these gratuitous issuances have caused. I got news for you. These people are going to get their fucking asses sued. And this is exactly the type of thing that corporations don't protect. The corporate veil doesn't protect. Receiver is continuing to obtain and marshal information regarding these areas of concern he is investigating. The receiver will continue to keep the court and the company's constituents updated regarding his findings and determinations. Yeah, folks, we'll get this posted so you can read through it and make your own conclusions, but
yeah, I had to mute myself. Sorry. The reason why the time, just have to apologize to everybody today. The reason why the time had to change is because my daughter had a medical issue that I have to deal with. She's fine, but she had a medical issue that I have to deal with. And that was who just called that I'm going to have to end it shortly.
okay, that's fine.
Yeah. But that's the summary report. I would like to do another one. We can talk about Doge because I would really like to talk about Doge, and we were going to do it. Maybe we could do it tomorrow or the next day. But after reading that report, after hearing the report, really, I mean, it doesn't make you feel any better about the conduct that occurred that at GTII. The receiver certainly has concerns as expressed in his report. The court decided a receivership had to be appointed. So it seems like things ran afoul. The receiver is out there trying to recoup money and shares. Obviously, has started the process. I hope they're successful. If anybody wants to assist, if you have any information to help the receiver, give it to the receiver, contact the receiver. Otherwise, we'll keep you apprised. And I think I said the next report probably January. If there's anything in the meantime, I'll keep you apprised. Like I said, I'm reaching out to corporate counsel to find out about the relisting and how that will be effectuated, what the timing might be of that. I don't know if they'll be able to give me a precise answer. And in the meantime, if anything else happens, we will update you, of course, about Alpine and anything else. And JR and we'll do a separate one about Doge and Looper and when we get a chance. If you have any questions after this, because we talked for a long time, hopefully it was not too dry and boring, and hopefully it was meaningful and you got some information that was helpful. And again, if you have comments or questions, concerns, when this is posted, please put those out there. And as always, we appreciate you listening to us and taking the time out of your day and following us. And we hope to continue this and put out useful information in the future. Anything to add, JR?
I'll figure out how to get it posted. So just
Okay.
give me a couple hours. I mean, I really have no idea how to do it, so I got to fiddle with it. So
okay. But if you go through it, it's long, but take your time. You'll find it's a pretty interesting document, and
yeah,
you draw your own conclusions after you draw it. By the way, it's not a final. Just so we're clear, it's not final. There's no final determination by the court. There's not been a trial or anything like that. This is kind of the ongoing investigation. And this will be the leading part of the case from this point until the report is done. And then there'll be a decision if there needs to be additional litigation at that point in time. Anyway, again, appreciate everybody out there for listening, and take care and have a great day. Be well, and we'll see you soon.